Is it Ms. Lewis? You ready? Please proceed.
Thank you. Good afternoon, Your Honors. May it please the court. We're here, as you already stated, you read the record, you read the facts, and we're here because there was a denial of summary judgment initially, and there was a reconsideration of summary judgment initially, and then a reconsideration was granted, was denied in reconsidering that granting of summary judgment. And it was all based on qualified immunity of an officer after the appellant alleged that the officer arrested her without probable cause. Ms. Perry was at her home, briefly, was at her home, and she is a very active participant in her community. She attends a lot of meetings as far as safe neighborhood type of meetings. We commonly know as neighborhood watch type meetings. She has a good relationship with the police department all the way up to the constable's office. And she's encouraged in those meetings to call if you see anything, any crimes, anything suspicious, just anything that would alert, that she feels the law enforcement should be alert of. Well, in this instance, she took it upon herself to go forward with the invitation to call when she heard loud music in the neighborhood, and which she did from time to time. In this case, with Ms. Mendoza, who was a Precinct 3 constable deputy, she was the third officer to arrive on the scene after Ms. Perry had called 3 times that day. Ms. Perry would complain that every time that officers would come, the neighbors would turn the music down, and then as soon as they leave, they turn it back up. And so with that, yes?
How do we deal with the fact that she called the DA or assistant DA to seek advice? How do we evaluate that in terms of how can it be unreasonable for an officer not to have qualified immunity when they go to the prosecuting authority to see what they're doing is okay?
Well, I think that under normal circumstances that would be fine, but we have to take into consideration what Mendoza told the district attorney. And I think that is the biggest issue here, is what the DA learned from Mendoza. And what she learned from Mendoza is that, one, that the neighbor, Resendez, was the complaining witness. 2, that there was an allegation that Perry had called hundreds of times throughout being in the neighborhood and called many times that day. And so based on those facts that were presented to the DA, I don't know if it necessarily shows in the record or the facts gave her advice, but that DA did
Accept the charges.
Right, accept the charges based on what was presented to the DA as far as the facts are concerned.
But the basic storyline was still the same. In other words, what Officer Mendoza said to the DA, the particulars may be in dispute. And look, I'm sympathetic to your client. I've been on HOAs and I've dealt with loud music and things like that, and so I'm really, my heart's sort of with her. I need to make sure the law is, because the bottom line is the DA said we'll accept the charges, just as you were discussing. So the officer, what else was the officer supposed to do before going in to make the arrest that happened? I mean, I guess, against the backdrop, the officer's been there for an hour or so and sat behind the fence and listened, didn't hear any music. She called a 4th time at that point, and so the officer then has some on-the-ground knowledge too. But the bottom line was the DA gave maybe erroneous legal advice, but the officer acted on it. How's that unreasonable?
Well, Your Honor, if we just go back a little bit, so the main issue is that it's not the fact that the DA gave erroneous advice, it's the fact that Mendoza gave erroneous information. And I don't...
But the information, just assume it is as you say. It would still be bad legal advice under the Texas Court of Criminal Appeals case law that she could be arrested either way, right? In other words, if the interpretation of that statute is the call has to be to the victim or the intended victim, it can't be to the police. It doesn't really matter how many times she called the police, 10, 4, 100. It would still be bad advice, right? In other words,
Right, but
it didn't accord with what the Texas Court of Criminal Appeals.
Right, but I don't think that excuses Mendoza. And before we get too lost in those weeds, it is the appellant's position that nothing that Mendoza says should be taken as true, because we have an affidavit, well, an alleged declaration from her that alleges that she stood behind a fence and she heard no music and this back and forth. But so nothing that she said that she told the DA should be taken into consideration.
Why not? Are you saying that this is a summary judgment case, right?
It is.
So those are facts in the record. Are there other facts that call those into question?
Right. So
Are there? Are
Right,
there other
so-
facts that call those facts into question?
yes, there are other facts that call those into question, which is Mrs. Perry's rendition of the facts, and that is that she heard the loud music playing. And when she heard the loud music playing, she called officers. There's no way for her to know what Mendoza could have told, that Mendoza was calling the district attorney. There was no way for her to know any of these things, and we don't know that.
So she can't, I guess my point is that there are facts in the record from the officer declaration. In order to create a fact issue, those facts have to be contested, right? She can't contest whether the officer called the DA. She wouldn't be in a position to contest that, right?
Correct.
Okay, so it would seem to me that the fact that the officer called the DA is uncontested.
Right.
Right?
She would not be able to contest that, correct.
So because it's summary judgment and it's a qualified immunity case, it's always important for us to determine is there a universe of facts that is uncontested on which we can measure qualified immunity.
Right, and we're talking about qualified immunity, and we're talking about probable cause. Despite what the district attorney believed to be the case, or what Mendoza believed to be the case, there was no probable cause.
Well, right. Okay, so let's assume there was no probable cause because of the decisions of the Court of Criminal Appeals that Judge Wilson referred to. Let's assume that. No probable cause because under the statute, it's only calls to the victim and not to a third party that can trigger that particular statute. Let's assume that. But in order to overcome qualified immunity, you have to show not only that there was no probable cause, but that the officer was unreasonable in the officer's misunderstanding about probable cause. And the issue here that Judge Mazzant referred to is that the officer actually called the district attorney, the ADA, and got legal advice. Now, maybe it was bad legal advice.
We refute that, Your Honor. We refute
What do you refute?
the fact that Mendoza called the DA and...
How can you refute that
Well,
Mendoza
the reason
called
why
the
is because-
DA?
I'm sorry, the only evidence we have is the declaration.
So,
The declaration cannot be taken as true
why?
because it's unsworn.
Oh, well, but the law is that if those can be put in an admissible form, then that's okay for summary judgment.
But that is, but if you look at the declaration, it doesn't even read properly together. This is something that it looks as though the attorneys put together and then submitted to the court. And that should not be taken. I submitted some documents to the court that just read the last paragraph of the second page, and that last paragraph, it states that the investigation into Ms. Perry's complaint about her arrest was not complete until November 6, 2017. The investigation, now we're going to the page they submitted that's signed, said the investigation, county downtown, while in the patrol car, I made a wrong turn, which caused me to then make a lawful U-turn at the next opportunity. Those sentences don't even flow together. That paragraph does not flow together.
I don't understand. Are you saying that it's obviously unsworn, but the law is that summary judgment evidence can be permissible if it can be put in admissible form? Are you saying that this declaration could not be put in admissible form?
What I'm saying, Your Honor, that this declaration is not from Maxnetta Mendoza. What I'm saying, Your Honor, if we just look at the only one document that has her signature on it that we could take into consideration, doesn't have any of those facts in it relating to what she told the district attorney and what the district attorney told her. This could be the only page that could be used as credible evidence, and that's 2096. Now, the page before it, this is nothing more than attorney argument. And we know that this is true because of the flow of the sentences. This is something that they put together on their own, and they...
Attorneys put together affidavits for their clients all the time.
That may be true, Your Honor, but if an attorney helps their client put together an affidavit, then that person still has the obligation to review that affidavit to make sure that it is true and correct, that it is what their words would say. And that is what's missing from here. On this declaration, it doesn't say anything about Mendoza attesting that this affidavit is true and correct, it's under the penalty of perjury, it doesn't conform to either the Texas declaration or the U.S. 1746 code as far as unsworn declarations are concerned.
But if we disagree with this, in other words, if we agree with what the district court held, which was, I'm going to count this as competent evidence because it can be turned into an admissible format. If we disagree such that the reliance on the declaration is appropriate, do you lose?
No.
So all these facts can come in and you still win.
Right, because of the fact that, Your Honor, what matters is that with the probable cause, what supports the probable cause here is simply that there was a dispute on whether there was this loud music and whether Miss Perry was calling the police department on a non-emergency line for no reason. And that is what Mendoza knew to be false when she submitted that information to the district attorney. She knew that we believe that she knew to be false.
All right, let's go back to Judge Duncan's line. You don't contest that Officer Mendoza called the DA?
No.
Don't contest that the DA said, we'll accept the charges?
We cannot.
So you say that Mendoza knowingly told the DA or told the DA incorrect things or misled the DA?
Yes.
Where's the evidence of that? What specifically did Mendoza say that wasn't true to the DA?
It is, well, I wish I would prepare for that particular question, but I will tell you this. If you, in my brief, there's a section where it actually shows a screenshot that says that the complaining witness is the Renendez. And that is something that is in the report to the district attorney. It's from the district attorney's office that the complaining witness was not Mendoza, but actually these neighbors who never complained. And so that would be something that I would point the court to, since you asked about where is it that shows that she gave false information to the district attorney. That's just one.
Can you point to a page in the record that shows that is a contested fact?
That
Resendez, whatever, was not the complaining witness.
There is no evidence to show that Resendez did complain at all. There's not a report. And in fact, she has in fact, Mendoza admitted that it was she that called the dispatcher and collected the evidence of the hundreds of calls for Miss Perry that was sent over to her in her squad car and printed out. And she called the district attorney as a result of all of the calls. And she was on the phone with the dispatcher the entire time and listened while the dispatcher, there's a call in the evidence in the record between the dispatcher and Mendoza that lasted about 40 minutes where they're just talking about all kind of things and from diet pills to everything else, just talking on the phone.
Is the call to the DA in the record?
No, it's not.
Let me ask you this. Since we're talking about qualified immunity, typically what we do is there's step one, which was the Constitution violated or a statute violated. But then is there a case, a controlling case that's fairly close to being on point, doesn't have to be dead bang on point, but pretty close to being on point, that would have told the officer what you're doing is illegal? Now, can you point to a case or cases like that?
A case where...
That would have given the officer notice that, okay, if I call the DA and I make this report and I get advice, but then I'm wrong or the DA's wrong, then I don't get qualified immunity.
Well, Your Honor, what I would say is that this goes to the credibility of Mendoza and whether
I'm just asking if you have any cases.
I do, and it's in my briefing. I can bring that back up when I come.
Okay, okay.
On my rebuttal. Thank you.
Thank you, thank you. You'll have time for rebuttal. Ms. Fraser.
Good afternoon. May it please the court, I'm here on behalf of Ms. Mendoza, and I want to be very clear. We are here today to decide if Officer Mendoza is protected by qualified immunity when all she did on that day is show up and do her job.
Well, I mean, I understand why you put it that way. The problem that I have is that, as I understand it, you have decisions from the Texas Court of Criminal Appeals that authoritatively interpret this statute to say that calls to a third party do not qualify. Now, I might not have read the statute that way, to be frank, but I'm not on the Texas Court of Criminal Appeals. So they read that. Now, does that mean that no qualified immunity? She violated the law, clearly violated the law.
No, for a couple of reasons. The first is that when Mendoza is out on the scene, she relies on the advice of counsel. She calls the district attorney and requests them to accept charges, and they say yes. I also think that we can distinguish these cases. In Scott v. State, as Your Honor's aware, that's really a First Amendment case, and the question there is whether harassment implicates the First Amendment free speech protection. And in addressing that, the court does talk about the victim being the recipient of the telephone call, but here the court is not focused on another. The court is focused on whether harassment is free speech.
Does that matter? I mean, it's a pronouncement of what the statute requires. It requires the calls to go to the victim.
I think it does because I also think, I think it does because I don't think that that's the holding. I don't think that's the central point. I also think that you are alluding to ex parte nuncio, and I'd like to bring to your attention that that case is 2022.
Yeah, that case can't possibly be relevant. It's too late.
But what nuncio does, though, is basically say our prior interpretation was right, doesn't it? I mean, in other words, it reaffirms what was in the case law before this incident happened.
It does, however, it's not controlling, but in addition, that case opens the door to the possibility that there's another interpretation, right? And there are some examples in the dissent, and there's a myriad of examples how you can call one person intending to harass another. And
That's
in
dissent.
I understand, that's not the law, I understand, but given the fact in this case that Mendoza called her attorney, called counsel, she can rely, I think that she can rely on that advice. I think that's reasonable.
Can she rely upon that when there is an interpretation, the statute, that there was no way to violate that in what was happening in this case?
I think she can, and I think that there are interpretations of this. I think that, again, even Wilson v. State is in the context of the First Amendment, and there the court is focused on the number of calls in the amount of time.
No, but it's a clear pronouncement of what the statute means to the Court of Criminal Appeals.
Understood, but also I would...
So it doesn't really matter if they call a lawyer, the DA does it, to get an opinion, albeit wrong maybe, when there's a clear statute saying you can't do this, and so there's a key element that can never be proven to get probable cause.
I think that under the probable cause standard, she can still rely on that because we're talking about an officer. We're not talking about a lawyer. We're not talking about somebody on scene looking at Westlaw. So I think that it is reasonable for her to rely on that. I think it is reasonable for her to rely on that.
Are there any other criminal statutes that she might have had probable cause to arrest Perry for?
Yes, there are. And as Your Honor is suggesting, it doesn't matter if she's arrested for that specific offense. And it is, I'm making a false statement to an officer, and I apologize, I don't have the actual statute, but there is, here we go, 37.08, false report to a police officer. I think that's another way she could have probable cause to arrest Perry.
But she didn't arrest Perry for that, right? Or at least she didn't say she was, or am I wrong?
I don't believe that she did, Your Honor. I would have to double check. But still, if you arrest somebody and you have probable cause, it's immaterial what crime you have probable cause for, as long as you have probable cause upon the
Does it matter that, as I understand the declaration, she was on site and sort of witnessing what was happening in real time? Is that right?
Correct. She responds, she's there for a number of hours, and I think what you're suggesting is the third call, she's actually standing, Miss Mendoza is standing behind Perry's home, hears nothing, as she's informed from dispatch that Miss Perry continues to call. In addition, Miss Perry's own affidavit says that at that time she was blow drying her hair.
Now, I asked counsel opposite about whether facts are disputed. In your view, what are the disputed facts here? Because obviously, as you know, we can't review disputed facts on a, I don't know, is this an interlocutory appeal? No, it's not. Okay, so that's irrelevant. Forget I asked. Are there disputed facts?
There are disputed facts. There are no material disputed facts.
What are the disputed facts?
The disputed facts are whether Miss Perry called in 100 times. There are she disputes the name of the victim who is listed on the offense report. There are a number of other disputed facts, but they're not material. And I think that the facts that give rise to probable cause are undisputed. And I'd also like to address the fact that Perry's own evidence includes support for the material information that makes the basis for the arrest. And those are on page 2202, 2259, which is the OR offense report, and 2243, which is the DIMS, which is later submitted to the district attorney. And that goes to the third issue, which is the declaration. But I don't believe, to answer your question, any of the material facts are in dispute. We know that Perry calls the police multiple times, at least one other deputy responds and doesn't hear music. Mendoza responds. She talks to the neighbors who say, no, we're not playing music. Then Mendoza hears no music the entire time she's on scene, and then she stands behind the fence hearing no music as she's understanding that Miss Perry is calling. All of this under the totality of the circumstances. A reasonable officer would conclude that the suspect was committing or did commit a crime. Probable cause requires a probability or substantial chance of criminal activity, not an actual showing.
Does the record reflect at what point she called the assistant district attorney in all this?
I believe it's in the offense report, but I don't know, Your Honor. I'm sorry.
I'm trying to, I take it that the record doesn't include a transcript of what she said to the ADA.
No.
But I'm wondering if it was before or after she was standing there witnessing what was going on.
It's as she's standing there. She's standing there and she's not hearing music while she's on with dispatch, who's conveying to her, hey.
Yeah, but did she call the DA after that?
Oh, I'm sorry. Excuse me. I'm withdrawn. I was referring not to the district attorney. I was referring to dispatch. I apologize.
That's all right. Did she call the DA after that?
Yes. Yes. And I'd also like to remind the court of qualified immunity. As you suggested, it's her burden, it's Ms. Perry's burden to demonstrate liability and defeat immunity. So she has to show that either Perry lacked probable cause or she has to show specific facts demonstrating a genuine issue of material fact regarding Perry's probable cause to arrest. And she doesn't. She doesn't rebut or address that Mendoza stood behind the fence within earshot, hearing no music at the same time she's being told that Perry's again calling. Her declaration, as the lower court pointed out, is silent on whether the music resumed after Perry's third call. And she also offers no evidence that Mendoza did not receive information from dispatch.
You know, I'm reading the declaration here, and it does recount that after she witnessed what was happening, she called the district attorney's office. I mean, correct me if I'm wrong, and the counsel opposite will, that she calls the DA, reports what's happening, and then it says, the district attorney's office said it would accept the charge of telephone harassment. Is that how telephone harassment got into this case? In other words, did the DA's office say, yeah, telephone harassment?
Well, often what happens is that the officers call and ask about charges. I mean, I know that that's what she charged Perry with. I believe that that's how that got into this case.
Okay.
So in addition, Ms. Perry offers no evidence that Mendoza did not receive information from dispatch that Perry was calling in a noise complaint as she stood behind her house. She's protected by qualified immunity unless Perry shows that the arresting Perry was so clearly a violation of her constitutional rights that every reasonable officer would have understood this as a violation. And I submit to you that is not the case. It's a high burden. It is not the case.
Is there any way, under the reading of the statute by the Court of Criminal Appeals, there can never be probable cause when the victim's not the one receiving the calls? Isn't that right? There can never be probable cause to anybody under that reading if the victim is the person not receiving the calls.
Yes, at least today after ex parte nuncio. And I think that's erroneous with all due respect. I can think of a million ways to
We'll
harass
have to
somebody.
take that up with those folks.
Yes.
On that. And, you don't think Wilson established that in 2015 or whenever that was, 2012? I mean, I know it was reversed, but
Right,
not
no,
on that point.
Again, I would urge that this was really focusing on the number of calls and the number of.
Yeah, I know, but what Judge Mazzant said is true. It states what the statute means. Now, the facts of that case probably have no resemblance to this case.
Correct. I mean, that was a kind of threatening by a friend, for lack of a better word. And I think that's really focused on the First Amendment. Do
you have a case where someone calls the DA, an officer calls the DA, that automatically gives them qualified immunity?
Wait, repeat, I'm sorry.
The idea of just by calling a DA to seek advice or to report and the DA says we'll accept the charges, do you have a case that says that if that happens, you always get qualified immunity?
Not at the tip of my tongue, but I can certainly research that and get back to
No,
the
I just didn't know if you had a case.
That's not, I mean, you're not arguing that, are you? You're not arguing that merely because she called the DA, she automatically gets qualified immunity.
No, Your Honor. No, I'm focused on the case and the facts before us. And I want to briefly, touch on the declaration, which, as Your Honor pointed out, under Federal Rule Civil Procedure 56C4, the affidavits or declarations must be made on personal knowledge and facts that would be admissible in evidence. This is certainly based on her personal knowledge and facts that would be admissible in evidence. And in addition, she does talk about on the first page that she's executing this declaration during a period when our country and state are under court and disaster declaration restrictions, would otherwise do this in a verification. She says it's based on her personal knowledge, and each of these facts is true and correct to the best of my knowledge. And in addition, there's additional facts in the record to support this. In fact, the pages that I previously cited to, this is Perry's own evidence, and it includes the material information that's in here. We contend under the statute that this is in substantially the same form as required under 28 U.S.C. 1746.
So if we, I don't mean to beat a dead horse here, but going back to, if we accept that the Court of Criminal Appeals decision in 2015 indicates there's no way there's probable cause, how does that impact, if we accept that as a premise, how does that impact the qualified immunity analysis? If there was no way there could be probable cause under these facts, if that's a clear pronouncement of the law back in 2015?
I think that it's still, in terms of an officer standing out there, I still don't think at that time it was so clearly a violation of her constitutional rights that every reasonable officer would know. right? I think,
But it's an objective test, so objectively, if the premise is true that that's a clear pronouncement of the law, that you have to make the calls to the victim to be under that statute, so there's no probable cause, how does Mendoza still get qualified immunity out of that objective standard?
I understand what you're saying, and I would go back to the fact that it's a reasonable, in the totality of the circumstances, it's reasonable for her to think that that is probable cause.
The particular statute that she was arrested under, I'd like to, well, I'll have to look at the record more carefully. If a DA says to the officer, you should arrest her for X, and it turns out there's not probable cause for X, I don't understand, how can we put that on the officer?
Well, that's an excellent point, and I think that's much more clearly stated than I
When
would.
you just told us that she might have had probable cause to arrest her for Y.
Well, as long as she has probable cause to arrest her for some crime.
Something.
Yes, is,
She's standing there watching what's happening.
right, I mean,
DA is telling her arrest her for telephone harassment. I'm just going with what the declaration says.
right, right. I mean, to me, it seems very clear that upon the basis of all of that, it is probable cause for telephone harassment.
Well, the other question I
Or-
guess is that you could mistakenly believe there's probable cause when there's not. Texas Court of Criminal Appeals says there's not under the statute. But the officer could mistakenly believe there was probable cause and still be entitled to qualified immunity. In other words, she could
Yeah.
still have acted reasonably or not objectively unreasonable.
Yes, a reasonable but mistaken but good faith belief can still establish probable cause.
Where's the line on that, though?
I don't think the line is this case. I think in this specific case, I don't think that,
Well, that's a good answer. And maybe that's the right answer, but I'm grappling with, here we've got, to Judge Mazzant's point, we've got the Texas Court of Criminal Appeals clearly stating there's no probable cause under this statute. Officer Mendoza gets, I guess, bad legal advice from the DA she talked to. We'll accept charges under this statute. That's just wrong according to the Texas Court of Criminal Appeals. So where is that bandwidth wherein the officer could still act maybe not objectively unreasonably, in other words, still be entitled to qualified immunity?
I understand.
Do you have a best case where, okay, it's like this one?
No, I do not at this time. But I do,
Is it to come forward with the best case?
but I'm sorry, I didn't mean to interrupt you.
The burden is not on you.
That's correct, Your Honor, is once qualified immunity is asserted, it is on the other party to refute that. And in addition here, she does have probable cause to arrest Perry for the other crime, which is false reporting to police. So, if the court has no more questions, I thank you.
Thank you. Ms. Lewis, you have 5 minutes for rebuttal.
Your Honors, if I could address a few things that have come forth. So, in order to find that there's a constitutional violation, we have to first find that there was no probable cause in a false arrest context. We first find that whether there's probable cause or not. It's clear here that there was no probable cause for the crime of harassment.
Probable cause for any other crime?
There's not. And the reason
Making
why I
a
say
false
that,
claim to the police, that's a crime.
right, but there's no probable cause for that crime in this instance.
Why not? She was standing there witnessing no loud noise, plus calls to the police saying loud noise. Why isn't that a false report to the police?
The reason why is because now we go back to, if the court does decide to entertain this declaration, we go back to competing facts with Ms. Perry saying, I heard the noise, and so I called, and
But the competing facts might be relevant on the merits of the claim, but when we assess qualified immunity, we're looking at the officer's perceptions, right? about whether there was probable cause at the time?
Well,
In
yes
other words,
and
what
no.
Ms. Perry thought inside her house and what she heard, we don't know. I mean, clearly she disputes it, but what she thought's kind of not relevant. We've got the officer who is on the scene firsthand, all that.
I agree.
Looking at it from the
I-
officer's perspective.
I absolutely agree, and that's in that regard. But as it relates to the arrest for making a false police report, that's where it matters, because Ms. Perry is saying, "I heard the noise, therefore, when I call." And mind you, this is a non-emergency line that she's a part of this community that is encouraged to call when you hear things. She called this line and she made her statement. This is her fact, that she heard the loud noise. We also have Mendoza with a competing fact to support an arrest for making a false police report, which says, "I heard no noise." So that matters. Whether there was noise or not matters. That's a competing fact to support probable cause. Now, Mendoza is setting forth this declaration claiming to have heard this noise. There's no way for Ms. Perry to ever say that, you know, where Mendoza was or how she was or what have you. That goes down to credibility and what a person would determine who's more credible. Did she really go stand behind this fence for all these hours and listen to see if she heard music? Did she really call during the time that Miss Perry, was she standing there at the time that Miss Perry called? Those things matter when it comes down to the additional charge of making a false police report. That is a huge distinction. Because you do have to have that fact that this person intended to contact the police department and claim that a crime occurred that was not occurring. And so that intent factor that Mendoza is imposing here is lacking, and that there's no way that she can show that. And furthermore, we have to remember that with qualified immunity, we're dealing with the fact that you have to have probable cause for an arrest. And just as Mazzant pointed out, it has to be from an objective, reasonable standard. So objectively, the fact that Mendoza inserted facts that are contested, and when I say contested, that Ms. Perry was not being truthful when she called in and said that she heard this loud noise to the district attorney, that does matter when it comes to the probable cause context of things.
So anytime a suspect of a crime says, no, that's not, the way the officer said it happened is not the way it happens, there's a fact dispute that defeats probable cause and therefore immunity?
Well, what I would say, this is in a civil context, yes, it does matter, because they're no longer, they're a plaintiff. They're no longer just a suspect of a crime. They now get to tell their side of the story and say that this is what actually happened. It's not just as simple as, a suspect of a crime wanting to tell their version of the facts, but going back to as far as what Perry, with Mendoza, here we have somebody who set forth this undertone that Miss Perry was lying and not being truthful, and so therefore she had to arrest her, and there was probable cause. And under the false arrest statute or the harassment, which is categorized here as telephone harassment, which is not a crime in Texas, of telephone harassment, is under the harassment, it looks like they're meaning to say code under the
It's
penal
not
code.
clear from the declaration what crime we're talking about?
Pardon me, I'm sorry?
You're saying from the declaration of the officer, it's not clear what crime we're talking about?
Yes, the false arrest based on the telephone harassment versus the false arrest based on making a false police report.
Okay.
And I just to clarify, as far as the declaration is concerned, she says it's telephone harassment, but the court asked, was there any other crime? And so I just was addressing that issue of it all.
Okay, thank you, counsel.
you.
The case is under submission.